Well, a victory for opponents of the NDAA. A federal judge has ruled that provisions in the controversial law may violate our constitutional rights. President Obama signed the National Defense Authorization Act back in December. The move has outraged activists that say the law is so vague it allows U.S. citizens to be indefinitely detained by the military without due process. But a group of activists sued President Obama, and yesterday the federal judge took their side. Here is part of the court order issued by Judge Katherine Forrest. It reads, quote, "This court is acutely aware that preliminarily enjoining an act of Congress must be done with great caution. However, it is the responsibility of our judicial system to protect the public from acts of Congress which infringe upon constitutional rights." So the law has been blocked, at least for now. To talk more about the case and the implications of it, I'm joined by Carl Mayer. He's co-lead counsel with Bruce Affron, representing the plaintiffs in this case. Welcome to the show, Carl. So a huge victory for you. Your reaction to the judge's ruling?
Thank you for having me on, Ms. Wall. My reaction is that in large part due to a district judge, federal district Judge Forrest, America is more free today than it was yesterday. This was a hugely important landmark ruling. It's very rare that a judge will declare unconstitutional an act of Congress. And that's what Judge Forrest did yesterday in a very sound, very reasoned, very persuasive and intricate constitutional opinion that held directly that when you have a law as vague as the NDAA, or the so-called Homeland Battlefield Act, that seeks to put Americans in jeopardy of being placed in a military brig or prison or in a military tribunal, that this is a fundamental violation of our free speech rights. It's also a fundamental violation of due process rights in this country, because people should be entitled to know the standards by which they would be judged. So this is truly a very important, very critical ruling by Judge Forrest yesterday. And right now, we're calling on President Obama to issue a statement publicly that he will not appeal this ruling, that what he will do is agree to enter into a permanent injunction so that never again will United States citizens ever have any concern that they will be placed in a military prison or placed in a military trial system where they have no right to a trial by jury of their peers, such that our freedoms will be forever guaranteed. And this is what President Obama ought to do. The judge has issued a preliminary injunction, which is indefinite. It means the NDAA cannot be used to pick up Americans in a proverbial black van or in any other way that the administration might decide to try to get people into the military justice system. It means that the government is foreclosed now from engaging in this type of action against the civil liberties of Americans. But the federal government could still appeal. They have the right to, but we are suggesting that it would not be in their best interest, because there are so many people from all sides of the political spectrum opposed to this law that they ought to just say, we're not going to appeal, we'll enter into a permanent injunction. And by the way, candidate Romney should also issue a statement on this, because this is such an important issue to the American people. There are members of the Republican Party, for example, Ron Paul, even Rick Santorum, for example, opposed the NDAA. So this is not a left or right issue. This is simply what it means. This is an issue about what it means to be an American. And the Bill of Rights was something that our ancestors fought to achieve, to prevent the British from exercising the control, sovereign control, and authoritarian control over this country. And it's incredible to me that we're even having this discussion today. But I'm sorry, you wanted to make a point?
No, I was just going to ask you, Carl, because this is just temporary. This is a preliminary injunction. And you said that the government can still appeal at this point. So are you confident that you'll prevail?
Oh, I'm very confident that we'll prevail, even if they do appeal, because Judge Forrest's opinion was a 68-page, very well-reasoned and sound opinion that relied on recent precedent in the circuit that we're in, which is the Second Circuit for the New York area, and Supreme Court precedent. So I'm very confident that we would win any appeal. Furthermore, a preliminary injunction is an extraordinary measure for a court to take. And what it says, in order to issue a preliminary injunction, the judge has to make a finding on the record. And there was a very extensive record on this case. In this case, the judge has to make a finding that, in fact, we will prevail on the merits should the case proceed. So the burden of proof is now entirely shifted to the government, and they have an uphill battle. And frankly, I don't see how they can surmount it. So I think that this will stand and that our civil liberties will be protected.
All right, now that we know what the legal standing of this is, we want to take a moment to talk about some of the arguments that have gone on here. And what has made the NDAA so controversial is how vague it is. And the fact that its vagueness, critics say it opens up all kinds of scary possibilities. The plaintiffs, you fear that even reporting on terrorists could be considered grounds for being detained under this law. And the judge acknowledged the danger of some of the language in this bill. Can you talk about that?
That's right. Sure. Absolutely. The language of the bill, for example, stated that anyone could be captured under the law if they were considered to give, quote, substantial support to al-Qaeda or other terrorist organizations, or they were even giving support to organizations that were enemies of American coalition forces, not just the United States. So it is so vague, these terms like substantial support, that even journalists or activists or citizens or protesters could be caught up in the act. And in fact, the people that were involved as plaintiffs here were, in fact, a former reporter for the New York Times, Chris Hedges, the legendary whistleblower, Daniel Ellsberg, and some very young activists who were involved with Occupy Wall Street. And incredibly, there were various security memorandums identifying Occupy Wall Street, Occupy London, and other affiliated groups as, in fact, terrorist organizations, which show, according to the U.S. government. And for them to label these groups that are largely peaceful protesters as terrorist organizations shows the assault that we're facing on our civil liberties and how important it is to stand up against this. And so, go ahead.
Just wanted to mention another argument that the government made is that the NDAA essentially just reaffirms a law that already exists, that law being the Authorization for Use of Military Force. This is a 2001 law, but neither you nor the judge buys this argument. Why not?
Right. That's an excellent question. You've really done your homework. That's a fantastic question. That the judge would have none of that argument because the authorization for military force was passed right after 9/11, and it was specifically targeted to either members of al-Qaeda or people who participated in the 9/11 attack. This law, the NDAA, goes so far beyond that as to make it a completely different and indistinguishable effort. It goes so far beyond that anyone who gives, quote, substantial support, and that could include a writer, a journalist, etc., could be caught up on it. So really the AUMF was a narrow law directed at people who commit violent acts and were involved in the 9/11 attack. And in fact, in the courtroom, Judge Forrest cross-examined the lawyers for the government and asked plainly, can you assure these journalists here that you will not be subject to the NDAA? And they would not. Multiple times, they refused to answer. They refused to give those assurances. They only said, we cannot give those assurances. We cannot give those assurances. And therefore, the judge found, and the record supports, that any journalist could have a reasonable fear that they would be prosecuted under this law. And that's why I think it's so important, not just to you and your colleagues who are journalists, but anyone who considers themselves an activist and interested in the truth. And I'll tell you another important point is that this really shows the critical nature of having a separations of power of government. To be able to have a judiciary review what the executive branch and the congressional branch do in order to make sure that they follow the Constitution. Because essentially here the executive branch and the Congress have colluded to create an entirely unconstitutional, anti-First Amendment, anti-due process system that is fundamentally anathema to American principles.
All right, Carl.
So delighted we could achieve this victory.
Don't mean to cut you off there, but definitely achieve something that a lot of people feared couldn't be achieved. Very interesting. Thank you so much for coming on the show. That was Carl Mayer. He's the co-lead counsel with Bruce Affron representing the plaintiffs in this case.